Welcome to Legal Studies, and today we're going to be learning about some more factors that affect courts' ability to make law. And in particular, today we're going to look at three different factors. We're going to look at the impact of cost, time, and standing on courts' ability to make law. So where are we in the study design? Here we are down here looking at courts' ability to make law, and we're looking at our final two factors. And remember, these are the things that can either help or hinder when courts are trying to make new laws. So most of what you need to know for this topic is going to come in the form of examples. You're going to need to research and find some examples of how expensive things are trying to go to court, examples of cases that had extreme delays, and examples of cases where this idea of standing was relevant. So let's jump into each of these things and flesh them out a bit. So the first thing we're going to look at is cost. Now, we're probably already familiar with some ideas and some examples around this, so this is a bit of a revisit from previous topics. But if we think about cost, some clear ways in which cost can limit the ability of courts to make law is that high costs can deter people from bringing a case to court in the first place. All right? If people don't have enough money to hire a good lawyer, they might just decide, I won't bother at all. And we know that courts can only make law if someone actually brings a case to them. So if the expensiveness of court cases, deters people from doing that, then courts are going to be limited in their opportunities to make laws. And the same thought process applies to appeals. Even if someone does bring a case originally, if they lose, they might say, I can't be bothered appealing it to one of the higher courts who can sort of overturn or reverse this particular precedent. So all of this contributes to making it much harder for courts to make law. On the other hand, courts do have some ways in which they can try to reduce the impact of cost. Our civil pretrial procedures, for example, are some of the ways that courts manage disputes to try and make them quicker and therefore cost less. And also this idea of costs, it might mean that, actually only the most important cases and legitimate cases are the ones that are actually going to end up in court, because they're the ones that are actually going to be worth the time and the money. And so it can make the court's job easier when they're making laws, because they're not going to be clogged up with all the irrelevant cases. They're just going to be focusing on the really important cases that actually make it to court. So there are some costs and there are some pros and cons in terms of helping and hindering courts to make law, but largely I think we'd be thinking about cost as something that really limits courts' ability to make law. Similarly with time, if people are worried about big delays with their cases, they're worried about the fact that their legal claim might take years to process, some people might just not bother. And again, that's going to deny courts the opportunity to hear cases and create new law. This is particularly the case when we're having to appeal all the way up to some of the higher courts in order to overrule or change a precedent. Having your original case heard and then appealing it can take months or years sometimes, particularly for complex cases. On the other hand, when it comes to time, there are some ways in which this can help or assist courts in lawmaking. On the one hand, courts actually can move quite quickly compared to Parliament. Parliament might spend some time thinking about what the right thing is, but courts, once the case gets in front of them, the case will usually be done. The hearing will take place over the course of a week or a couple of weeks, and then the decision is made, and that's it. It's implemented. Right? So it happens relatively quickly once the dispute actually arrives in the courtroom. And that can assist courts in making law quite quickly. They can respond rapidly once the case is in front of them. And unlike Parliament, they don't have to get involved in this lengthy process of developing, drafting, a new law, getting feedback in the form of debate, which can really stretch stuff out. So again, time can either really help or really hinder courts when it comes to lawmaking. We can make arguments for both ways. Our third factor that we're going to look at is this idea of standing, which we've covered in the past before. Standing basically is the idea that you can only bring a case to court if you are actually involved in the case in some way, if the law is relevant to you in some way. So you can't challenge a law just because you feel like it. The law has to affect you in some way. It has to have some sort of impact on you. And the main purpose of that is to make sure that we're not getting extravagant or frivolous cases, useless cases being brought to court just by people who want to make trouble. We're only letting people bring cases to court if the law's actually affecting them. So, an example of this that we've seen in the past is the McBain case. Now, in that case, single women were being prevented from having IVF fertility treatment. They were being prevented from accessing those treatments by a Victorian law. And this law was challenged, but it wasn't challenged by any odd person. It had to be challenged by someone that was impacted by the law. And so the person who stepped up was a doctor. Someone who had been trying to perform this IVF treatment and had been prevented from doing so by the law. So they had standing to challenge it because they were impacted by the law. Now, if you had been a innocent bystander at the time, someone who really strongly believed that we shouldn't be preventing single women from having fertility treatment, this is wrong, you wouldn't have been able to challenge that law, no matter how wrong or bad you thought it was, unless you were directly impacted by it, like this doctor was. So that's our example of what standing is. In terms of how it helps or hinders courts in lawmaking, well, it can really limit the courts in lawmaking by, again, making it harder for courts to get cases in front of them. If we're restricting the number of people who are able to actually bring a case, well, we're making it so that it's harder for them to pursue a legal challenge. That means less cases end up in court, and the courts have less opportunities to make new laws. On the other hand, this can help the courts in making law by ensuring that the courts are not clubbed up with irrelevant or frivolous cases. Only cases that are actually brought by people who are genuinely affected and there's real need for change are brought to the court's attention. And so they can spend more of their time thinking about whether the law should change and what sort of changes they should make, and they don't have to worry about irrelevant and silly cases. So it helps them be faster and more efficient in a way. And this also encourages people not directly affected by a particular law not to waste the court's time and instead use other avenues to try and get the law changed. So maybe they could send a letter to Parliament or something. So again, by saving courts time, it allows them to focus more deeply on the cases that matter, and that helps them make more effective laws. And that is our 3 factors for today. We've learned about cost, time, and standing, and how each of them can both help or hinder courts when it comes to making laws. See you next time.